So now let us look at the normal taxation of profits under Irish law, where basically Ireland said Commission didn't understand Irish law. And then specifically we look at Section 25 first, this rule about non-doms. First, Ireland and ASI and OE take issue with the Commission's application of Section 25, insofar as it complained, in essence, that the Irish tax authorities had not required all of ASI and AOE's profits to be allocated to their Irish branches, because the Commission basically said you had nothing outside of the branches, so all the profits of the company must be the profits of the branch. But then the court looks at Section 25 and says, under Section 25, in the case of non-resident companies carrying on their trade in Ireland through a branch, only the profits that derive from trade directly or indirectly attributable to the Irish branch on the one hand, and all income from property or rights used by or held by or for the branch on the other are taxable, but not anything that doesn't have anything to do with the branch, right? So Ireland submit that the taxation mechanism precludes in principle an approach in which the entirety of the non-residence company's profits are examined, and to the extent those profits cannot be allocated to other parts of that company, are allocated by default to the Irish branches. And this is crucial. And Ireland had an expert witness to come with this, and they have case law to support it. And really, this is where the Commission lost the case. So we see here the court says it is apparent from the judgment in data products, which is the case law that they refer to, that the profits derived from property that is controlled by a non-resident company cannot be regarded as being profits attributable to the Irish branch, even if that property has been made available to that branch. So this goes very far, right? And it says similarly, it's apparent from that judgment that property belonging to a company that is not resident in Ireland and controlled by executives of that company who are also not resident in Ireland cannot be allocated to the company's Irish branch, even if that property is made available to the branch. And what Apple said is, listen, you know, these non-doms have board members in the US, and they control all the intellectual property, right? So there's the parallel with data products. And the court then says that remains the case even where it is only the Irish branch that had employees, like we have in Ireland with Apple, and physical property, and the non-resident company has no physical property, employees, or business activities other than those of the Irish branch. The non-resident company with no employees was considered to control that property through its management bodies. And the Apple Group IP licenses held by ASI and AOE were not controlled by the Irish branches. If they were not controlled, and we'll see that they were not, it would be wrong to allocate all of the income generated by the companies arising from those licenses to the branches. And this is where the Commission goes down, because the court says we have to apply Irish law, because if Irish law is applied to everyone, then there can be no selectivity. And if Irish law, rightly or wrongly, says that if there is nothing else in the company but a branch, and the assets or the income is not directly linked to the branch, then it cannot be taxed in the branch. Then that is what Irish law says. And then applying that law does not lead to selectivity. So this was the death blow, as far as I'm concerned, for the Commission's case. I'm not saying this is good law. I'm just saying this is what the law was. So to summarize, the application of Section 25, Article 25, only taxes Irish branch income, and the data products case show that this is the case even if there are no other employees in the company. Now let's get to the arm's length principle. Ireland submit that the arm's length principle is not part of Irish tax law, and that no freestanding obligation apply that principle emerges to that principle, and that no freestanding obligation to apply that principle emerges from Article 107, which is a state aid article. And then a bit of background information here. Ireland did not have transfer pricing rules in its law until very late, I think somewhere in the early 2000s. So it's a fair argument to make from them, but the Commission raised a number of points regarding this, and let's see what those points are. First, the Commission said the Commission maintained that Section 25 had to be applied by using a profit allocation method. And they're right? I mean, if you have a branch and you say you're only taxing the branch income, then somehow you have to allocate which profit goes to the branch and which profit goes to the rest of the company. And that requires transfer pricing. Second, the Commission stated that according to the judgment in Belgium and Forum 187 versus the Commission, the court decided there that transfer pricing rules had to be applied. Otherwise, you confer a selective advantage on the taxpayer for Article 107. So Form 107, that 187, that was basically the Belgian rules on notional interest deductions and head office companies. And it's true that the court there has said, these things must be at arm's length, otherwise there is a selective advantage. So in other words, for state aid rules, arm's length principle applies. Then the Commission contended that the purpose of the arm's length principle was to ensure that transactions between integrated group companies are treated for tax purposes by reference to the amount of profit that would have arisen if the same transactions had been carried out by non-integrated standalone companies. Otherwise, so just the arm's length principle, otherwise, integrated group companies would benefit from favorable treatment under the ordinary rules of taxation because they could deal at more favorable conditions than unrelated parties can by definition, which means that they could shift profits. And so by definition, you must apply the arm's length principle in order to avoid state aid. Then the Commission said that the same principle applied to internal dealings of different parts of a single integrated company. So in other words, the arm's length rules do not only apply between companies, but it also applied between branches and head offices. And then the Commission said that they did not directly apply Article 7.2 or Article 9 of the OECD because I think the argument there was these were not applicable because they are just guidance. It's not binding law. And the Commission said, well, we didn't apply them, we just referred to them. And finally, the Commission stated that the arm's length principle that it applied was derived from Article 107 of the TFEU as interpreted by the Court of Justice. So in other words, the Court of Justice have applied the arm's length rules, and what it meant was which was binding on member states and from the scope of which national tax rules were not excluded. It noted that the principle therefore applied regardless of whether a member state in question had incorporated that principle into its national legislation. In other words, because the Court of Justice apply the arm's length principle when looking at state aid, it means that all the other member states must apply it, even if it's not in the law. Now, I'm not going to go through the court's analysis of this and the arguments, but in the end, the court basically said the Commission was right. The arm's length principle does apply, even if it wasn't in Irish law. Part of what it says is that Ireland in practice has applied the arm's length principle since 1984 already. And therefore, the Commission won this point. The arm's length principle was applicable to transactions between the branches and the rest of the Apple enterprise. So just to summarize, as far as the arm's length principle was concerned, it was applicable to allocate profits under Article 25 of the Irish Income Tax Act, and it was applicable under Article 107, the State Aid Article, for the Treaty of the Functioning of the EU. So now the next point was whether the Commission applied it correctly. So first it was whether the Commission could apply the arm's length principle. And then the second question is whether the Commission applied it correctly. And here things do not go well, because Ireland's plea claims that the Commission's own application of the arm's length principle was inconsistent because it failed to take into account the economic reality, structure, and particular features of the Apple Group. In other words, this thing that the IP was not managed from Ireland, right? In its primary line of reasoning, the Commission concluded that the Apple IP Group licenses held by ASI and AOE should have been allocated to the Irish branches due to the lack of staff and physical presence of those companies, without attempting to show that that allocation followed from the activities actually carried out by the Irish branches, right? So it never looked at that. It simply said there's no one else to do it, so it must be the branches. The Commission, in addition, inferred from that conclusion that all the trading income of ASSI and AOE should have been regarded as arising from the activities of the Irish branches, without attempting to show that that income was representative of the value of the activities actually carried out by the branches themselves. And we come back again to this point where the fundamental mistake made by the Commission, at least in the eyes of the court, was that it didn't look at Irish law and practice, where it said, that even if there are no other people to do the functions in an entity, if the functions are not done by the branch, then you cannot allocate the profits to the branch. So the court concludes it must be held that the arguments raised by Ireland are well-founded. So if we look at the conclusion here, the group IP licenses should not have been allocated to the PEs, and nor should the group IP license income have been done so. The next point that Ireland made was that it said that the authorized OECD approach to the allocation of profits to PEs was used by the Commission, and that is simply not applicable in Irish law. Again, it's a politically a pretty bold statement to sit at the OECD, approve the AOA, go through all the motions, and then when it comes to a state aid case before the EU, you say, oh, no, but we've never done the AOA. You don't understand. It's not applicable in our law. But I guess it shows the political power of Apple in Ireland. So let's see what happened here. In essence, Ireland and Apple submit that the authorized OECD approach does not form part of the Irish tax system, and in particular does not apply in the context of taxation of non-resident companies provided for in Section 25. This is this non-dom article, right? But then a few paragraphs further, the court says, when specifically asked on that point in a written question put by the court and orally at the hearing, Ireland confirmed that it was necessary to carry out an objective analysis of the facts, including first identifying the activities performed by the branch, the assets it uses for its activities, including intangibles such as IP, and the related risks that it assumes, and second, determining the value of the type of activity on the market. Now, obviously, I mean, if the non-dom article says that when you have a branch, the income of a branch is taxable in Ireland, you're going to have to determine the income of the branch, and you probably are going to look at functions, assets, and risks, just like you would under the AOA, right? So the court concludes, contrary to what is claimed by Ireland, it is clear that it is essential that there is essentially some overlap between the application of Article 25 and the functional and factional analysis conducted as part of the first step of the analysis proposed under the authorized OECD approach. The Commission cannot be criticized for having relied in essence on the authorized OECD approach. And this is one of the things that I love about the European courts, is that they look at the substance of matters. They do not look at just, the formality, the wording, etc. They look at what it is that you do. And if what you do is very similar to what the AOA says that you should do, then apparently you are applying something that may not be the AOA in your law, but something that looks a lot like the AOA. And if it walks like a duck and it talks like a duck, we should treat it as a duck. Okay, so now we know that the Commission could apply the AOA, and the question is, did the Commission apply it correctly? And spoiler alert, this goes the same way as the question whether the Commission could have applied the arm's length principle and whether it applied it correctly. So Ireland submit that the Commission's primary line of reasoning is inconsistent with the AOA, inasmuch as the Commission considered that the profits relating to the Apple Group's IP licenses should have been allocated to its Irish branches of ASSI and AOE. Insofar as the executives of ASSI and AOE did not perform active or critical functions with regard to the management of those licenses. So they say, well, you know what, this should not have been allocated to ASSI and AOE because they didn't do those critical functions. And the court responds and says in its primary line of reasoning, the Commission considered, in essence, that the profits of ASSI and AOE relating to the Apple Group's IP had to be allocated to the Irish branches insofar as ASSI and AOE had no employees capable of managing the IP outside those branches. But that is, again, like the court said, this is an exclusive approach, and you cannot say just because there's no one else to do it, it must be the branch doing it. And so, as Ireland and ASSI and AOE rightly argue, the approach followed by the Commission is inconsistent with the authorized OECD approach. And part of what went wrong here is that the authorized OECD approach also demands a function assets and risk analysis. Now, the irony is, remember the AOA comes from 2010. And in those days, it was indeed so, and that's probably also the law you should apply, which said that you had to look at the functions as a risk of where they are. But then we went through BEPS, and we went through Action 7, and we went through basically allocating profits to ghosts when it comes to commissionaire PEs and things like that, where the OECD itself said, you know what, you don't need to have people on the ground in order to allocate profits there. And I wonder if the court looked at this case more with eyes of BEPS Action 7, more with eyes of Pillar 1 and Pillar 2, whether they would have come to a different conclusion. On the other hand, I think this is the right conclusion, because as much as countries might like to argue that Action 7 and Pillar 1 and 2 to some degree is an interpretation of existing law and not changing existing law, I think that is not the right way to go. So again, the Commission crashes on the fact that Irish law didn't say that that you can allocate the rest to the PE, and nor does the AOA. And the fact was that this simply wasn't managed by the PE, and it wasn't managed by these companies. It was managed by Apple, and the companies never should have had that income. But that was not the case that the Commission brought to the to the court. So our answer to the question that the Commission apply the AOA correctly must be no, only functions actually performed by the PEs should have been included. And what is interesting here, and it's something that was not highlighted in this case very much, is there is funny language in the AOA about the allocation of assets, right? The allocation, the court reverts to it indirectly, but not explicitly, and it is a pity, because the AOA says that if a PE uses assets, then the default rule is that those assets have to be allocated to the PE. Now, the sales activities must have been conducted through the PE. In other words, that the IP must have been used through the PE, which means that those IPs should have been allocated to the PEs. But that point probably would not have gone very far, because if you then say, well, you have the assets, but you don't have the functions to control those assets and to manage the risks which are allocated to it, you would simply have to allocate under transfer pricing rules post-BEPS the profits from those assets back to where those functions are performed and where the risks are controlled, and that would have been ultimately back in the US again. Let's go to the activities within the Apple Group. Finally, let us briefly look at the activities within the Apple Group, where basically Apple said the Commission didn't understand the way Apple worked. Now, this is divided into the activities of ASSI's branch, which clearly showed that it had nothing to do with the IP, and the same for AOE's branch. Then they looked at other activities, and these were basically, these branches were doing low risk routine activities, but the other activities that they were looking at was the strategic decision making within Apple. And it turned out that everything was basically done by Apple from the US, obviously. And then they looked at the decision making for ASSI and AOE, and those were basically concerning low risk routine issues, such as how do we produce these things, and do we build a certain expertise in producing these Apple computers, for instance. And then we come to the conclusions. So let's look at the conclusions, because most of the case has been chewed out when dealing with paragraph 2. So Ireland submit in essence that the activities and functions performed by the Irish branches of ASSI and AOE represented only a tiny part of their economic activity and their profits, and that those activities and functions included neither management nor strategic decision making concerning the development or marketing of IP, because those decisions were really taken by people in the US who were on the board of these companies, and that's the way it worked. So rather, Ireland submit that all strategic decisions, in particular those concerning product design and development, were taken following an overall commercial strategy determined in Cupertino and implemented by the two companies in question through their management bodies, right? So this is what the Irish have said. This is the way Apple worked. So there were nothing decided regarding IP in the branches, and then you can't allocate any IP decisions or value-adding activities to the branches. And then the court says, insofar as it's been established that the strategic decisions were taken in Cupertino on behalf of the Apple Group as a whole, the Commission erred when it concluded that Apple Group's IP was necessarily managed by the Irish branches of ASSI and AOE because there was no one else working in these companies. And then the conclusion for the whole of the Apple Group is it is apparent that the Commissioner has not succeeded in showing that in the light first of the activities and functions actually performed by the Irish branches of ASSI and AOE, and second, the strategic decisions taken and implemented outside of those branches, the Apple Group's IP licenses should have been allocated to those of the Irish branches. And here they lost the case, because if the intangibles are not allocated to the branches, then they cannot get the income connected to those intangibles, and then they weren't treated specially for not allocating that income to them. So this is the end of the decision as far as I want to discuss it. There has been some other arguments made by the Commission, but quite frankly, all of it somehow relates to that the branch did everything and therefore should have gotten everything. And as we saw in the first line of argument, that argument simply does not work, because that's not the way that Irish law works. And if Irish law does not work that way, then there can be no selectivity. And that's how the Commission lost this case. I hope you enjoyed the case. If you have suggestions for any other cases, please let me know. Bye.